everyone. My name is Connie King, and I'm the Safe Babies Community Coordinator for Douglas County. It is my pleasure to introduce our speaker this morning, Judge Connie Cohen. I've been fortunate enough to learn from Judge Cohen through the Safe Babies Project, as she's one of the original judges that's been with the project for the longest time. And Judge Cohen has been a juvenile judge in the 5th Judicial District of Iowa in Des Moines since 1994. Her jurisdiction includes dependency, delinquency, termination of parental rights, involuntary juvenile commitments, and adoption. Prior to attending law school, she was a teacher and school administrator. Professional legal experience includes private practice, prosecuting attorneys training coordination for the Iowa Attorney General, and adjunct professor at Drake University Law School and Des Moines Area Community College. She's a former member of the Board of Trustees of the National Council of Juvenile and Family Court Judges and continues to serve on the Permanency Planning Committee. Other professional activities include Model Court Project Lead Judge, Safe Babies Court Teams Lead Judge, Chair of the Juvenile Court Committee of the Iowa Judges Association, Lead Faculty, 2005 Child Abuse and Neglect Institute, and CJFCJ. Member of the Court Improvement Project Oversight Committee, National Association of Women's Judges, Polk County Women Attorneys, and Iowa State Bar Association. She's received the Iowa Judges Association Award of Merit in 2003. In 2004, she received the Iowa Judicial Branch Court Innovation Award for her work as lead judge for Model Court. She is the recipient of the Drake University School of Education's Outstanding Alumni Award for 2007. And in 2007, Judge Cohen was also awarded the Congressional Angels in Adoption Award. Judge Cohen is a frequent lecturer at local and national conferences and has served as an adjunct professor at Drake University Law School and the Des Moines Area Community College. Please help me in giving a warm welcome for the Honorable Judge Connie Cohen.
But she sounds really old, doesn't she? I mean, me. I'm going to have to revise that bio to make it sound like I haven't been around so long. Well, good morning. I don't have a PowerPoint, so if you want to step a little closer, because I do have chocolate. Isn't that better than a PowerPoint? There's a reason. Chocolate's always good, right? I should make people come closer.
It's up here, guys.
And this is a small enough, but I really want it to be interactive, so, and they're making me stay up here for the video. So if you feel, like you don't want to be in church and come a little closer, that would be great. Well, I'm really delighted to be here. I think I probably passed Connie one time on my way to and then from Colorado, but I don't think I've been here before, and I'm really happy to be here. I was worried about the construction, but it wasn't so bad. I was on the bench yesterday morning, and I left at about noon, and we drove over, and Connie was a little farther than I thought it was going to be. But and my good friend Doug Johnson, judge in Douglas County that works with Katie, warned me that there would be this construction, and that you also have a grant up and running to increase the speed enforcement on Interstate 80. So since he knows my husband, and he knew my husband, who's a former cop, so you know what they're like, what they're led to be, he warned us not to speed. But I'm just telling you, just for what it's worth, Nebraskans do generally drive faster than Iowans. The speed limit on Interstate 80 in Iowa is 70. And if any of you are planning to make a trip from Nebraska to Iowa City the day after Thanksgiving, there's a little event in Iowa City, then it's important that you remember that we drive a little slower. And I'm not saying that the troopers might be more inclined to stop you if you have a Nebraska license plate in the vicinity of Iowa City, but just saying, you want to be careful. But I do have some good ties to Nebraska. My brother and his family lived in Omaha for many years. My sister-in-law made the trek from Omaha to UNL every day for 3 years to go to law school. We were both older when we went to law school. She blames me for going first and making her go, which I take no responsibility for. So, everybody has to sign up for that craziness on their own. So I got are you all attorneys in the room? Because that's the way it was built. Okay, great. Well, I'm here to talk to you today about reasonable efforts. And this is a term that I think people really do diminish and kind of minimize when it is in fact the center of everything. It's like the central nervous system of all the work that we do. And it touches everything that we do. And if you don't use this reasonable efforts to the maximum degree possible, you're missing out on a lot of opportunity. Lawyers sometimes ask me to, find somebody in contempt of court, usually the agency. Then how many of you represent parents and or children? Okay, and how many represent the state or agency? Okay. So you're here to find out what they're learning to use against. Contempt of court. And there are some judges that like to do that. I'm not one of them. I don't think it's effective. Because let's face it, that agency worker who's sitting in the witness stand, who didn't get something done, probably didn't get that something done that should have been done, granted, because he or she really wanted to tick me off or be a bad social worker and not deliver services. But it was probably because of things beyond her control. And a much more effective tool, I think, is to ask the court to make a failure to make reasonable efforts finding. And how many of you have ever done that? I've asked, okay. And how many of you were successful? Good. All right. So it works, right? And do you want to talk about all the circumstances under which you did that and were successful?
I've done it actually more than once.
More than once, okay.
It's primarily a situation where they don't get evaluation.
Could I ask you to, could I get you to come up here and talk to the mic? I wouldn't do that. I wouldn't do that if I had I can't hear you and there's this camera. I'm sorry. No good deed goes unpunished. Maybe I can find a prize for you. Okay, good. I have one. All right. And that's okay. We press these up. Oh, you're just like he stole that idea from me.
I was just saying, I guess I use it primarily in situations where I'm really frustrated because the cases are getting off the ground because evaluations aren't done. And so I think that's a pretty easy one. They're ordered to do an evaluation, and if nothing's scheduled, that's pretty easy for a worker to do. There aren't a lot of excuses, so especially in a case where there are mental health issues, that's really, other services aren't going to be helpful because the person isn't coping because they're taking medication and they're not taking care of a psychiatrist. So that's what I primarily I've been successful.
And you were probably successful because you had a relationship with your client, and he or she was honest with you, right? And more or less. And they, it wasn't their fault. They hadn't blown out the appointments. They hadn't missed their rides. You talked to them about that.
Right. And sometimes they're blame all the way around, but primarily it's a situation where they're ready, willing, and able to comply, and somebody hasn't followed up and taken care of what you've done for them to be able to participate in the court orders or something.
Thank you. Very great. Thank you. Now no one's going to raise their hand. But I do have one more delicate if somebody else wants to share their story. Thank you. Come on up.
She wants to.
Well, my voice is really loud.
You are good, yeah.
Yeah. Okay. Besides what Monica has said, which is what I've used, I've had occasions where there have been multiple caseworkers and nobody's taking responsibility. You have a caseworker for 4 weeks and another one lasts for 6 weeks and nothing gets done. In that kind of situation, I don't blame you. There's no caseworker because they're gone, but I still asked the court to make a no reasonable efforts finding and it's not the department. So it's not going to be on my client, that's not my client's responsibility that there's such a turnover of our caseworkers. So I have been successful also doing that.
Great. And let's face it, people are people, and if you are the reason that social worker goes to jail or has to pay a fine, then, say you're in a rural county and that's the only social worker available to work with your client, what kind of relationship do you think that your social worker and client are going to have with one another after, your client's going to be out because, I put your, what in jail because you didn't do your job. And the whole problem-solving, successful tools are out the window. You're not going to be able to probably repair that relationship. Not all judges know about this tool. I was rather shocked a couple of years ago, kind of tell a tale on one of my colleagues. And this is a colleague who has been on the bench a long time, connected with the Safe Babies Court team, connected with the National Council of Juvenile Family Court Judges, see him at all these conferences, and he was bemoaning the fact that he had ticked off the agency because he was demanding that they do more family contact, more family interaction. And they were really bucking him on this because they didn't have the money to do it. He was in a very large geographical jurisdiction, and so the kids were often placed, like 2 hours away and from their birth parents, and there were transportation issues, all the things we all struggle with. And he said that he's this close to finding them in contempt of court. And so I said, well, why don't you just make a failure to make reasonable efforts finding? And I almost fell over when he said, I don't think we have the ability to do that in my state. This was like 2 years ago. I mean, reasonable efforts has been around a long time. And I said, well, yeah, you do, because it's a federal law. And it's been a federal law since 1980, and it was refined in 1997 with the Adoption Safe Families Act. And yeah, you do. He said, haven't you ever read Len Edwards' letter in Resource Guidelines? I hope you're all familiar with this book. If you're not, you need to be. And so he goes, well, yeah, I think I've seen that book before. Well, this is the Bible of Best Court Practices since 1995, and this is really what led to the Adoption Safe Families Act. A lot of what's in here is in ASFA in 1997. No coincidence that this preceded ASFA. And I said, well, look at page 167 in Resource Guidelines, and there is a prototypical letter of how a judge can respectfully and effectively find a failure to make reasonable efforts. And this letter from Judge Edwards from Santa Clara County, California is masterful, and I have used it and plagiarized it, and everybody can. But you should read it because it will give you some ideas, some arguments to make, and some power to put behind your request for failure to make reasonable efforts. And has anyone ever met Judge Edwards? And he's like the nicest man in the world. He's retired now. And he says, I am writing to explain why the juvenile court has made several no reasonable efforts findings in the past few months, and why I believe the findings need to the department. And then he goes on to kind of recap what the law is and what the issues are that resulted in the failure. One was the department didn't provide a placement for teenage mothers and their babies. Wouldn't that be wonderful? I wish I could do that. The second is failure to provide intensive in-home services to enable drug-abusing mothers and their drug-exposed babies to be placed together in the community. And he said, and he goes on to praise the social workers that appear in his court. They are working hard to prevent the removal of children and to provide services to facilitate reunification. But they are unable to provide the services on the scale to which I refer. Instead, they report to me in court that they looked everywhere and these services do not exist. And he believed that they were reasonable in his community to develop. And he goes on to say that, you know, he realizes how important this is. What's the main reason that the department doesn't like these? And I don't like them. Nobody likes to do this. What happens as a result of building a reasonable efforts finance?
There's federal money.
Right, cannot draw down the federal $40 for that case until they fix it. So if I have a case in, say on January 10th, and I make a failure to make reasonable efforts finding, and the last hearing I had before that was September 1st, between September 1st and January 10th, DHS has to give the money back that they drew down for that case. And they don't get to claim any other money for foster care or group care unless and until it's fixed. And we come back to court and I make a favorable reasonable efforts finding. So it really gets the agency's attention. It hurts everybody because all of our states need every cent that we can draw down from the feds. But at some point, there has to be a standard. And if nobody upholds a standard, and if nobody's brave enough to ask for the waiver of reasonable efforts, and if the judge isn't able to maintain enough neutrality when the facts require it to make that reasonable efforts failure finding, you know, then the standards are going to cease to exist. Yes.
Are you aware of any appellate decisions on that issue?
Not in Iowa, not Nebraska, and from my experience, my own personal experience after having made these findings, you know, one time it was, I mean, they fixed it by 4:30 that day, that very day they fixed it. Because basically everybody wants to do the right thing. And judges can do it well, or they can do it not so well, I think. My position is that if I'm going to take a failure to make reasonable efforts finding, I'm going to call the agency, I'm going to call my service area manager, I'm going to call all the muckety mucks, I'm going to email them, and I had to make a failure to make reasonable efforts finding today. You know, I kind of do Len's letter and explain. And then I will set another hearing within a very reasonable time. You know, I'll think, and I'll talk to people. We'll do some problem solving, which I think is so key. You know, once you've adjudicated, you need a problem solving approach. That's what works best. Because isn't the initial goal to unify? And so, you know, we have that problem solving session in my courtroom after I make this finding. And I say, what's it going to take and how much time do you think it'll take? And who do you have to talk to? And then does he have to talk to somebody? Does she have to talk to somebody? And what's the food chain here going to be? And, you know, what would be the earliest you think you could get this fixed if everything goes well? And if they say 3 days, then I set the hearing in 3 days. So that I'm minimizing the amount of money that we're going to lose. And I think that sends a message to everybody that, you know, I don't want to be punitive. This isn't about being punitive, but this is about accountability. And if the judge doesn't hold people accountable, who will? And if you don't give the information to the judge that enables the judge to do her job, the judge isn't going to be able to hold anybody accountable. Information has to be transmitted. And information cannot be transmitted in an informal way. It has to be on the record. It has to be in the courtroom. I don't know if you deal with that issue of judges wanting to sign orders in chambers and not come out and deal with people. I hope you don't. We have made a big push in Iowa because, you know, ASPA doesn't allow that. Paper reviews are not permitted. How can you have a paper review and comply with the Adoption and Safe Families Act if you're not asking the parents, are you satisfied with the sufficiency of services that you're receiving? And in Iowa, I didn't do the research specifically, but they're in Nebraska, but hey, if you don't complain today about the fact that you've asked for bus passes and you've asked for this and you've asked for that, and you haven't gotten them, you don't complain today. When we come back to court in 3 months, it's too late. If a petition to terminate parental rights is filed, it's too late. You gotta complain now. And you gotta ask for services that you need when you need them and demand them. And if you can't get them from your social worker, then you need to call your lawyer and get a hearing set. Because it's too late to complain later on. This is your opportunity to tell me if you're satisfied with the sufficiency of services, so I can gauge whether or not this state is doing its job. Yes?
We're not generally filing for no reasonable efforts on situations where there's not a group home or something like that. More routinely, it's courts ordered X services, orders 1, 2, and 3. I'm a big believer, as a parent's lawyer, that these no reasonable efforts findings essentially identify the lawyer failing their job. Because if a lawyer asks for HHS help on getting a service and doesn't do anything for 3 months and then comes into court and says their caseworker hasn't done anything, the lawyer's failed for the last 3 months. You don't stop at the caseworker, you go to the supervisor, you go to the administrator, and you should never have to be in a position to seek no reasonable efforts. So I'm as big a critic as lawyers failing their jobs as saying HHS hasn't done what they need to do. So I've never been a big believer that the no reasonable efforts finding is necessary unless it's just absolutely the end of the road and the administration is saying we're not going to provide the services that are court ordered, which never happens. So I just don't know what that is.
And that's a great point and a great point to make.
Yeah.
And it tells me the kind of relationship that you've established with your clients. And I wish I could say that every lawyer in Nebraska and Iowa and everywhere has that real-time information from their client and it knows what's going on and has that good communication level to allow that to happen.
The people around are saying this happens in Douglas County where they're refusing services. So in other places it may be necessary. In Lancaster County, I don't ask for no reasonable efforts because it hurts everybody. And coming to court in 3 months and complaining about it says you're not a very good lawyer.
Right. It's much better to get those services demanded and delivered. Effective advocacy can do that. Yes?
Are there any, I'm struggling to see the benefits in the unreasonable efforts finding as opposed to holding not the worker in contempt, but the entire department in contempt if the services are provided and paid for. So what are the benefits to the no reasonable efforts finding as opposed to holding in the department?
Because it changes the culture at every level. If I put a social worker in jail.
But what if it's an order that the department can't find until the service is provided?
That's a better way to do it, I think, and I have done that on occasion. There was one time where it was truly the social worker's fault, and we had a contested hearing, and I determined that it wasn't the supervisor's fault, it wasn't the social worker administrator's fault, it wasn't the state's fault. That this social worker was clearly told at a hearing, do not set dad's family interactions on Tuesdays and Thursdays. He complained on the record at the hearing. I keep telling her I work Tuesday and Thursday nights. I can't do these visits on Tuesday and Thursday nights. I put it in my order. Social workers shall assure that father's visits are not scheduled on nights she knows he works, because the work nights could change. And we came back 3 months later, he had the same complaint. He said, so dad's attorney put her on the stand. I wish dad's attorney had done what you did, and fixed it earlier. But all this time had gone by, and she had no reason for it. So I did find her in contempt. I'm not saying one size fits all ever, but that would be an example of a time where it really, but it's after a hearing, it's after due process, it's after notice, it's after everything. We're going to figure this out. And I was able to hone in on the source of the problem. And it wasn't the social worker administrator, it was that person who just was incompetent overall. And you know what? As a side note, the administrators appreciated that in a way because they needed to get her out of there. And this was another paper for the trail to get that accomplished. Yes?
In response to what's the benefit of blocking reasonable efforts, as a parent's attorney, we're not looking to protect the department. The goal is reunification of the child with the family. And you only have a certain amount of time to do that. And if, 8 months go by because of a failure on the department, that ultimately counts against the parent. And if you're looking at the termination of parental rights, as a parent's attorney, your goal is to protect that time frame. So oftentimes, I will call, before I file it, I will call the department's attorney, or I will call the administration and say, I'm getting ready to file this. What are you going to do to fix it? And what can you do if we can't essentially toll this time frame to not have it counted against my client in these reports to the court? Because we are looking at a termination. And I've tried to come up with ways with judges where even after I file it, say, okay, I'm not looking to take away federal funding. I don't care about that part. It's not about punishment to the department as a whole or to lose funding. It's about, let's not have these 10 months count against my client when clearly there was a blatant misuse of services or things were done wrong or not referred. I mean, I've had workers lie to me and say referrals were sent when they never were, and come to court repeatedly and say my client missed appointments, where after I subpoena the file, that's just not the case. And
Okay, yeah, you could be presenting this lecture.
So that went on for months, but you don't find it until you get a subpoena and actually get the in-focus printout and ask, where did that referral chain go? Oh, well, it shows that it went. So the administration even thought it had went, but talking to the worker, well, we put it on the screen, but it didn't actually get to the doctor's office. Oh, so it got sent back, and then the money didn't go through. I mean, just a whole mismanagement. It was admitted by the worker, but that should never count against the parent.
Right, and that's why it's so key to bring this up at every opportunity when there's that failure, because it can operate to give your client more time. And that is in the federal law, that's in the Adoption Safe Families Act, that's reasonable efforts law. It will toll the clock ticking against your client for that 15 of 22 months or year. We look at a year. And in Iowa, as I was saying in the session before this, if the kiddos are under the age of 4, that time frame can be 6 months. Termination of parental rights can occur if a child is adjudicated to be a child in need of assistance and has been out of the home for 6 months and can't come home today. Boom. Those are grounds for terminating parental rights after only 6 months, which seems harsh, particularly in the face of the problems that you and I face. Because I know that your issues are like my issues. Methamphetamine, now we have this designer drugs, prescription drug abuse, we have mental health issues, trauma, historical trauma. We're all dealing with the same kinds of things that take a lot longer than 6 months to fix. And we can give more time if the parents are working on it. We can find compelling reasons to continue those timelines, but not forever. And if we don't get started right away, using this time as effectively as we can from day one, at first hearing, then that opportunity is going to be lost. And that clock is going to tick regardless. One of the things that I've implemented is at the adjudication hearing. Once I've adjudicated a child in need of assistance taking jurisdiction, I set the permanency hearing for 2 reasons. I got a really busy docket, and the lawyers have busy schedules. And number 2, the parent whose brain is not fully functioning because it's half fried from meth or whatever, they need something in black and white. I used to say, well, I have only 12 months to help offer services to reunify with the child, so it's really important that you tell me what you need. No one's a mind reader, and we have this conversation at every hearing. And I used to say, I only have 12 months, or I only have 6 months. The state can file in as little as 6 months for the date of removal, which is June 12th. But that's still pretty abstract for someone who's deer in the headlights about all of this. And so I've been putting that date in black and white in my orders so everybody knows. And then I say, permanency hearing shall be held on October 10th at 3 o'clock, unless otherwise ordered. And I would say, I want to order otherwise. I hope that your work will enable me to do that. I want to cancel this hearing. Okay, yes?
How is the department doing providing services in their rural areas? Because we have a lot of problem with rural areas not being able to get the services that our parents need. And so what is Iowa doing to meet those needs in the rural areas?
Okay, did you all hear that? What's Iowa doing to meet the needs in rural Iowa? You know, each area has its challenges. I practice in a rural area. I preside chiefly in an urban area now. But even the urban areas have transportation problems. That's one of our biggest issues. Even in the Des Moines area, you know, we don't have very good public transportation. And if a child is in a suburb, you know, there's no bus between here and there. One of the things that we've employed is a real problem-solving atmosphere in the family, utilizing family team meetings and within the courtroom after adjudication. I sign people up, say, okay, Grandma, you're not able to provide 24/7 care for this child, but do you have a valid driver's license? Do you have car seats? Could you transport the children to the therapy session? Can you take mom to visits? And we do this sort of problem-solving patchwork approach, and the enormous increase in utilization of kinship care has really helped us do this, to connect the services. Now, the services have to exist. And I do find usually that they exist, but it's the transportation barrier that really needs the solution, and you have to patchwork that and try to figure out what works for this family and have backup plans. And the judge also has to be told, well, yeah, she's about to lose her therapy appointments. You know, they won't make another therapy appointment because she missed 2 therapy appointments. Then you have to take that to the next level, and the judge knows it wasn't my client's fault. You know, there was a reason for that. She was in the hospital, or you know, there was really a legitimate reason for that. Her ex broke in and stole her phone. Services have to be grown, though, and that's something that you need to be at the table. You need to know what the evidence-based practices are, and you need to be rallying for them. I think that everybody in the system has an obligation to identify services and grow them. We know that Part C of the IDEA, when we're working with children 0 to 3, those services are entitlements. And if they are not developed in your community, then they need to be. That's the law. That's the Individuals with Disabilities in Education Act. That's been the law of the land for a long time. You have is it the EDN, is that what you call it here? The Early Development Network. And so you do have those services that are required to be made available. Early Head Start, those are other great places to begin to connect families. There's a network, what's it called? So there's several therapists that have signed up to take a certain number of pro bono clients, and what's it called? Home Within. Are you familiar with that? So you can talk within your community, sit at the table with judges and DHS, or I keep calling them agency workers, and everyone, get them at the table and say, all right, who's qualified to provide these services, and let's connect you to a Home Within, because they get perks for doing this work, much like you do for your pro bono work that you get. A little pat on the back or something. They get something more substantial than that, though. I think they get some $20 million or something. So it's important that you identify and grow evidence-based, effective services, and make sure they're evidence-based and effective. Parenting classes. How many of your parents are going to parenting classes? Are they effective? Some are. You know, there are some evidence-based ones. The Parenting Way, Incredible Years, and they really do augment the practice of parenting, but they don't stand alone as a good reasonable effort to reunify. My dad, I'll tell you a story on my dad. He had some heart attacks. He was older, stubborn old guy, survived 2 theaters of World War II. An amazing man, but very stubborn. Had some heart attacks. So I'm talking to the doc. I said, he shouldn't be driving. Well, he's from Missouri. I grew up in St. Louis. And she said, you know, in Missouri, if I don't see him keel over and lose consciousness, I can't write the DOT and tell them to take his license away. And he was almost 90 years old, and he should not have been driving. And those were the only times we raised voices and yelled at each other. So on that topic. And so we convinced him to take a driving class. You know, he said, well, doctor, don't you think I can drive? Because I've been driving since I was 12. He said, well, Mr. Cohen, you know, I'm not sitting in the car with you. I can't evaluate your judgment, your reaction time, okay? But there's this class here at the hospital that you can take that does that very well. So a couple months go by, and he calls me and says, I'm here to tell you, I'm looking at my certificate. I have successfully completed the driver safety class. I said, Dad, that's great. Did you take that class at the hospital that the doctor told you about? No. Well, what class did you take? I went to the AARP class. Flags. They said, oh, really? He said, yeah, 8 hours. I said, oh, and how much of that 8 hours was actually spent behind the wheel? None. Well, was there a simulator, you know, where they could evaluate your reaction time and your judgment skills and your motor skills in general? No. So I said, well, so what you're telling me is you have a certificate saying that you made it to a location and you stayed awake for 8 hours. That's what you're telling me. I said, Dad, you remind me of all these drug parents that come in and say, I took this parenting class, so give me my kids back. I said, it's not safe. That doesn't mean you're safe to drive. And he was not happy with my response. He said, isn't it just like you to rain on my parade? But you really do need to ask questions, you know, even if they're uncomfortable, and find out, you know, what is really working. And parenting classes are not a substitute for parent coaching. They're not a substitute for dyadic therapy, for parent-child interaction therapy. These are things we know that work. And with these little kiddos particularly, this comes back to attachment assessments, dyadic therapy, parent-child interaction therapy, what else, Katie? In your communities. I mean, there are entitlements for that 0 to 3 population, and that includes the parents. The parents are there. Parents need to attend all of your children's appointments, be they dental, medical, neurological, whatever appointments there are. Children need to see their parents at their recitals, at their football games. And if you need to clarify with the judge, even if there is only professionally supervised contact going on right now, well, is there a problem if mom and dad go to the football game? As long as the custodial aunt is there, you know, and just can kind of eyeball, make sure there's not anything inappropriate going on. You know, isn't that going to foster that reconnection? Because let's face it, the pain, you know, I can't imagine what it would be like for somebody who will take my child. But I know that, you know, and we all know, the things that are most painful are the things we avoid. And the longer we don't see our children, the harder it is to get that courage to put your heart out there again and have that scab ripped off once more. And so it's so important that family interaction be clarified at the first hearing, and hopefully before the first hearing. Our first hearing is 10 days. You know, that's ridiculous. 10 days, children and parents are separated through, you know, for nothing the children did wrong. And so you really need to fashion ways to expedite meaningful family contact before a day goes by. There needs to be some kind of arrangement made so that the parents know when they're going to see their children and the children know when they're going to see the parents. And I'm very protective of the caretakers that are relatives, particularly, and make it clear that, you know, it's great if you want to supervise contact between the parents and kids, but I want to save you for taking care of the kids, and I don't want you to go, oh, I can't do this. They have to go to foster care. You know, that's asking too much, so let's ease into this, and let's see how the drugs things are going to before we get there. But you need to keep pushing for that interaction to be lessened, because the research shows us that children are moved to a less restrictive placement 9 days before the hearing. So if you're not pushing for earlier hearings, if you're not pushing for these changes, inertia is a really tough thing to fight. Yes.
Did you say that you participate in the family team meetings following the hearing?
No, I don't participate in family team meetings, but I get notes about what happened. And we also have what we call pre-removal conferences, where parent partners, and that's another service you can really grow. You heard from Denise Moore, our parent partner coordinator. That's going throughout the state now, urban and rural. Is everyone familiar with that program? It's like an AA sponsor. And that's another great person to have at the table, because they've been there, they succeeded, they can give a person a sense of hope. And when they're deer in the headlights and they don't understand anything that's going on, you're their lawyer, you can talk them down, but you probably haven't walked in their shoes. How often are you really able to say, with integrity, I know how you feel? Parent partners can say that with integrity. They do know how those parents feel. And they can be the best bridge between you and your client and success. So did that help? Growing services, I think we all have a responsibility to do that and make sure that they're effective. Yes.
Judge, I practice solely in Woodbury County, and one of the problems we have with family team meetings is we go to court and we don't have the services, and the caseworker will say, well, the parent should have asked for it at the family team meeting. But the problem is, while they may send an invitation to the parents' attorneys, they could care less if you can be there or not. So we get these parents who walk into a family team, they don't know what they need to ask for. And then when we get to court, we're lucky that we have some judges who will find failure to make reasonable efforts. But that's the argument we're getting. The parents' attorneys are being left out of family team meetings. And I've had to have, I just had Judge Timko order last week that as guardian ad litem, they had to schedule a meeting when I could be there. But that's becoming a huge problem for us.
Well, it's too bad that it takes a court order to do that, but that's what you have to ask for. That's zealous advocacy. That's the right thing to do to get the result you need. And every now and then, you've got to do something like that. Let's face it, we all went into this field because we wanted to shake things up a little bit and advocate and make better things happen for the people we're serving. And sometimes, something like that has to be done. It's unfortunate, but thank goodness that Judge Timko did that. And what kind of a message does that send to the community? You think they'll work out around pretty quickly? Oh yeah. I know when I do something, it gets back to me in a minute,
Yeah, the downside is I'm going to a family team meeting as guardian ad litem, and if a parent's attorney isn't there,
you can't talk.
I sometimes feel like I have to help that parent's attorney out by saying, your clients need these services. Because if that attorney's not there to ask for it, and the parent doesn't know, DHS isn't going to offer.
Well, and that, I think that's okay, because you really are advocating as guardian ad litem for what's best for your clients. And that is for the parents to get the services they need in order to be parents again, because that's always best. I've gotten distressed about parents' attorneys not going to these family team meetings, and now I rarely hear that complaint. And if somebody said, well, I didn't know about that family team meeting, I'm the one who said, who dropped the ball? Why wasn't the parents' attorney invited? Or was it changed? And another strategy that I started using, if we need a family team meeting before the next court hearing and everybody agrees, the time and date is in the order. Say before you go, figure out when your next family team meeting is. Call the facilitator, get the schedule. Yesterday, it was beautiful. Yesterday, the DHS worker brought the facilitator scheduled to the courthouse, to the hearing. So there was absolutely no excuse. You have to set the judge up to eliminate excuses. And without knowing about the deficits, the court cannot be effective. and without getting on the bench. Do you have that problem in Nebraska where some judges don't get on the bench? Things are happening. Oh, good. You're gonna have to figure out how to fix that.
I think there has to also be an effort on the behalf of the parent attorney to work outside the 8 to 5 workday, because, you know, parents need to have those meetings a lot of times in the evening. Sometimes they're on Sundays, and we have a lot of attorneys who won't agree to work in those hours where it's family friendly.
Did any of us think this was an 8 to 5 job when we took it? Yeah, that does surprise me. And we have a pretty good culture where I'm from. And it gets tricky when you're in a rural area with a limited number of attorneys to appoint. But I do think that with some education, and don't we want these parents to have jobs? We want them to be working during the day, or you know, being in other services. Maybe it would help to do, you know, what I just talked about, try to get those family team meetings scheduled in the court hearing. And then, you know, that attorney might be less likely to say, I don't know, we're going to work after 5 to a judge. You know, because I would say, well, I do a lot of work after 5, and I don't get paid an hourly rate for it. That, you know, maybe we need to find somebody else to represent this parent who can be at all the hearings, be there at all the events. Because in our, you know, in our world, if guardian ad litem goes to the family team meeting and parents' attorneys are not there, unless guardian ad litem has gotten a release to talk to the parent, you know, you can't even ethically talk to the parent. And so if the parents' attorneys aren't there, it really disadvantages them, and it's almost pointless to have the family team meeting, I would think. I don't go to them. I don't know, maybe they would still be of value, but why would you miss that opportunity? That's where the real work gets done. I don't kid myself. You know, that's where the rubber meets the road.
I just, in response to that, we used to have, I worked about the dogs, we get, we're appointed on just about every juvenile case, which means we cannot attend family team meetings that occur during the day or court days. We can't do it. That used to be, the family team meetings were in the evenings. We always could make those. Now, they're during the 8 to 5 day, and my feeling is that it's now to suit caseworkers. I have caseworkers who say, well, it may be hard for your client to get you a visit at this time, but they need to show that they really want to do it. It may be hard for you to get to these meetings, but if you want to be there, it's, I mean, there's a change. And I don't know what to attribute it to, but it's a change. It's not a helping situation in my area.
Yeah, that's a problem. My suggestion to you would be to engage the higher-ups at the agency, because I think in our community what happens is, you know, we have flex time. And what social worker, you know, isn't going to want to take time off to take her own baby to the doctor for a well baby check, you know, and take that time off from 1 to 4 and then make it up at a family team meeting after hours. It sounds like it's maybe a time for a sit down, or I don't know if there are union rules. I don't know if they're unionized, and maybe that is a barrier, but you know, our workers are unionized and they have all kinds of flex time. We never get that. The child protective investigators get paid more than the social workers that work with the families after the case. They're always after hours, and so if they want to aspire to that next level, like maybe that's part of motivation. You know, they have to show a willingness at a social worker 2 level that they're, you know, going to be available after hours. And what happens between 8 and 5? Not much. Yes.
Yeah, I'm on that board. I do both Karen and Virginia. I'm a special prosecutor working in Douglas County. In Douglas County, we have what I deem an unusual situation. Is that the bench, the juvenile court bench, will not permit attorneys to lock themselves out, period, for any reason. So it doesn't matter if you've got a family conference that's scheduled, that you can't be blocked out. So if you end up with a conflict, oh well, you better get coverage for your hearing type of thing. So it's a real problem for the bar in Douglas County, because again, you'll have folks that will have more than one juvenile court case assigned, and even if you're able to coordinate, which is, some of the case managers are very good about, you have massive email chains trying to come up with a date for a family team meeting, and there's only so many evenings in the week, and again, it's easy to say, well, you should go to your case at 7 o'clock at night and have a family team meeting, but you do have to go home sometime.
Right.
And so again, to my knowledge, the agency in Douglas County is not unionized. The department workers are unionized, so they don't, doesn't matter what you attend any of the family meetings. The CFOMs don't do that the way it's set up. So, but again, there's a number of hours in the day. You can only be so many places in the evening. You can only schedule so many things that are in West Omaha in lunch hour, because you don't make it, you have to back and forth. You literally cannot lock yourself out for anything if you are a counsel in Douglas County. So that's a real barrier to being able to do a variety.
Well, yeah, we utilize a lot of noon hours, I know, for our family team meetings. But there's a culture in our community, and maybe you can get people at the table to agree that a previously scheduled juvenile court matter takes precedence. And you always set everything for the next hearing at the current hearing while you have it.
Well, it depends. Sometimes it just comes out in the order, but it doesn't matter because again,
you're at their beck and call.
You're at beck and call because you can't block yourself out. So again, you think, so there's a lot of times you'll see, I plan on being there unless I have to go to court. And so that's frustrating for the social workers, it's frustrating for the family, it's frustrating for every member of the team.
Well, I would think as a community, you would need to know the commitment from the bench, the value they place on family team meetings, and the reality that you need to be at these, because this is the role the sleeves plays. And so what can we do to accommodate? Is it worth sitting and trying to get that conversation going? Can you find one person do you want me to talk to, Doug Johnson?
At this point in time, you cannot lock yourself out to go on vacation. It'll come out, it will come out in the orders of Douglas County. They will say, if you can't be at the hearing, you have to get coverage. Well, sometimes that's fine if you work in a firm that has 20 attorneys in it. If you're a 1 or 2 or 3 person firm, it makes it very difficult to be able to get coverage.
But it's not really okay, because your client deserves to have the person they have a relationship with at every meaningful event.
So that's a consistent barrier that's been going on in Douglas County for a couple of years now. So again, we have defense counsel for parents that have no kids. I mean, they can't be at family team meetings at 7 o'clock or 8 o'clock at night because they have family responsibilities. So a lot of times, parents' attorneys can't come because it's not that the agency is not willing to schedule with them, but the realities of life is that, I really can't leave my kids to daycare until something.
Well, I'll be glad to talk to Judge Johnson about that. I think I have just about 5 minutes left, is that right? So I do want to cover just a few more things. These questions have been great, and I hope you have found some solutions. I've woven in a lot of what I was going to say anyway in the answers, but remember that you have some case law about waiver of reasonable efforts as well. And like Iowa, there is no requirement that you have noticed that somebody's going to ask the judge to waive reasonable efforts at the disposition or review hearing. And so you want to be prepared for that, and you don't want to be surprised because then your client is completely left in the dark. Like, what is going on? They're not going to do this anymore for me. They're going to file a petition to terminate within 30 days. It's only 6 weeks into the case. Why are they doing this? So just be really aware of that. I think it's your Dasquez case that says you can't, that if there's clear and convincing evidence, it raised the standard of proof to clear and convincing that the parent has subjected the child or another child to aggravated circumstances or any other, those reasons, that reasonable efforts can be waived without notice. Now, what I've been doing as a matter of practice, and I think fairness, fundamental fairness, is recognizing these cases. You know, if it's, you know, the fourth meth baby that's born to this mother, and I terminated parental rights 3 other times, and she hasn't seen the child since it was removed through no fault and through all fault of hers, then I'm going to say at adjudication, are we going to be addressing, or I will be addressing, waiver of reasonable efforts at the next hearing. That you should speak up and say, if anyone's going to be asking for that, I would like to have notice so that that's on the record. Utilize that record. It's critically important in the practice tips that I gave you the materials to participate in all events, and we talked about that. File motions to require reasonable effort services. Let people know. Don't keep them guessing. And document those requests for services. It is troublesome to try to say, well, what do you need? And they don't know what to ask for. They're in a foreign land. They don't know what's out there. That's why you need to help them navigate that. And let's see, you want to stay away from continuances. That just hurts everybody. You need to evaluate your client's cognitive skills and determine, do they have some ADD going on? Do they have some trauma? Nearly every one of our parent partners has disclosed sexual abuse by a caretaker when they were children. Nearly every one. So these are traumas that need to be healed. You need to be informed about trauma-informed care. Make sure your clients are able to access that. Incarcerated parents. Do your incarcerated parents have representation? All right. Find out what services are available there. Most of the prisons in Iowa have very appropriate visitations facilities, physical facilities. And so you want to rally around, again, line the relatives for who can take Johnny to see that, or make sure cards, letters, photographs. If they have a reading program, some prisons have a reading program where a parent can audio tape a book, and then the book and the audio tape are given to the caretaker, and the child hears the parent's voice, or you can do the 2-book thing. I was talking about this in my last session. It's not that expensive. You know, you get a couple books, and you get on the phone every night. Mom calls at 6 o'clock. Caretaker goes through the book with the baby on the lap and listens to the mom on the phone reading the book. And this helps foster that relationship if mom can't do those bedtime routines. Parents need to recognize that they're the experts about their children. Only a parent knows that, you know, what their favorite foods are, the foods they don't like, their favorite songs, what their bedtime routine is, their favorite blanket, their favorite toys. Enlist the parents' strengths, because even a really incapable parent knows a lot about their baby, and build on those pearls that they can share. And say, this, you know, what can you do for your child? What, you know, she refuses to wear these kinds of shoes, so don't even try. Try to foster opportunities. Norma Ginther, family contact guru, who says, why wouldn't I, as a foster parent, she's done a lot of things in her life, including chairing she's commissioner of the Ohio Department of Human Services. So she said, when I had this teenager foster child who is a pain in the butt to take shopping, why wouldn't I want mom to do that? Let mom have that fun. Let mom come over and do the homework. Invite mom over. And we have more and more great foster parents that are doing that. You need to continually evaluate your client's needs and ask the court to reject a permanency plan. Say, you know, this plan doesn't cover the reasonable efforts. You can say, DHS, do it over and make a good case for that. And make sure that you demand clarity with respect to barriers to reunification. Ask those questions. You know, what are the dangers? Why can't these children go home today? What are the barriers? And, you know, the department worker having concerns is not enough. We need facts. So, I have included in the materials Iowa standards of practice for attorneys representing parents. I hope those will be helpful to you. They're in draft form. And, you know, you also want to be looking at concurrent jurisdiction plans. That's the way we do it. You know, is there a guardianship? Is there a way to get this case closed successfully and safely with another parent or another arrangement? So know about reasonable efforts 1, 2, and 3 so that you can make those demands in a timely manner and demand meaningful judicial oversight. Housekeeping services, transportation assistance, childcare, budget training, parent skill training, mental health, substance abuse evaluations, therapy, treatment, attachment assessments, dyadic therapy. All of these things are reasonable efforts that are a requirement of the agency. I was at a judicial conference a couple months ago, and you know, a strong message that I really believe in was really brought home, and that is, in developing relationships, you know, it isn't often what you say whether you're a judge or an attorney, but it's how you present yourself. And they did some surveys, all this scientific research stuff, and they said that if a judge took the time and talked to people and explained their ruling, adverse or everybody or your client's happy, they walked out feeling really good about that experience, that customer service. So I know you're busy, that you have a revolving schedule at night, you know, you push one out to get the next one in, many of you. But building those relationships is so important. And they actually said that the scientists found that the parents and the litigants who left the courtroom after having that dignity, that respect, that feeling that they were heard, and the feeling that the judge looked at them and explained things and asked if they had any questions, that they had the same serotonin levels that you get right after eating chocolate. So you can give people chocolate that adds no calories, but I kind of laughed to myself because I always have chocolate on the table in my courtroom before I heard that. So if you didn't get your serotonin lifted today by anything that you heard in this room, hopefully the chocolate Hershey Kisses will help. And I wish you the very best in your continued advocacy for these people that need you so very much. Thank you for your time.